As I said that everything is under the terms and conditions of the contract of carriage, which is evidenced in the bill of lading. So, any deviation from the contractual terms and conditions is called a deviation, and it is considered a breach of contract, and the consequences are very severe. This is as per the Hague-Wisby rules also. What is the meaning of deviation? It is meaning that anything that is not done as per the terms and conditions of the contract of carriage, and more importantly also as per the normal customs of the normal ship operations and normal shipping business. Anything that is not done either of them, it is a deviation. So therefore, deviation is meaning that you are supposed to follow the shortest possible route between the load and the discharge port, which is the custom. For example, if you are going to Europe from India, the custom is that you will take the route which includes the Suez Canal. Obviously, there is another route also, that is via the Cape of Good Hope, southern tip of South Africa, and then go up north. That is also an alternative route, but that is not the customary route. That is not commonly followed. So without rhyme or reason, you decide that it will be as per, we decide to go there for whatever reason, it will be treated as a deviation. I'll give you an example. I was at Barber's at a car carrier, and because we were going from Europe to Japan for loading, and on the return passage, we used to be about 60% load with BMWs and Mercedes cars for South Korea and Japan. Because had we taken the normal customary route through the Mediterranean Sea, Suez Canal, etc., we would have reached Japan at a certain time where the cars would have been not ready. They were still in the process of being manufactured. Finalization. So the contract of carriage was amended that please, we will pay for the additional fuel, come via the Cape of Good Hope, take your time, and then reach Japan just in time so that there is no waiting period. So until and unless it can be shown that there is a custom to follow another route and it has been agreed upon. Had the contract of carriage not been amended, it would have been deviation, and on the owners, that is NYK were the owners of the car carrier, it would have been a very big breach of contract by the people who had hired the ship to carry the BMWs and the Mercedes, and they would have taken the NYK to court and claimed for millions of damages because as we saw in the previous slide, consequences are very serious. So it was agreed upon, it was shown. The circumstances surrounding the passage made it clear that the intention of the parties involved was that some other route should be taken. The general rule is we follow the shortest route. We do it for passage planning, but there are other implications also. So the practical thing is that we should be able to join the dots in all the applicable routes. It can be shown that it was necessary for the ship to leave the contractual route for reasons of safety and welfare. And of course, when is the deviation excused? The three things, very simple. To save life, property is always of the ship, life, property, and the environment involving the own ship. Two, in responding to a distress call in responding to a distress call to save life, property, or the environment involving another ship. And finally, in order to follow the law of the country where the ship is supposed to be calling. What we did in voyage policy, in insurance, and the same thing is applicable here also. Then there are two types of deviations, lawful deviation and an unlawful deviation. The example that I gave, that it was agreed upon among all the parties involved that the ship will go via the southern tip of South Africa via the Cape of Good Hope. It is a deviation. It is not the normal route that is followed, but because it has been agreed upon among all the parties, it is a lawful deviation, and lawful deviation is never a breach of contract and there are no consequences. Similarly, in responding to the emergency on board the ship to save life, property, or the environment, or in responding to a distress call to save life, property, or the environment involving another ship, all of this is lawful deviation. And when, without any of these emergencies or in consultations with all the parties involved, if there is a deviation, that is called the unlawful deviation. An unlawful deviation is a breach of contract where the consequences are very, very serious. So when you are talking about a deviation in your exam, you will be writing this plus the what is lawful and unlawful deviation, and under what circumstances the lawful deviation is excused. With regard to the bills of lading, there is always a P&I bunkering clause and deviation. Now, what happens is when this clause is added in the bill of lading, or the contract of carriage, that is P&I bunkering clause. In the bill of lading, there are no clauses. It is there in the contract of carriage. But after all, the ship owner would want to pick up bunkers where it is the cheapest. Now, the cheapest bunkering port may not be on the direct route from load port to the discharge port. So there would be a deviation. Now, the question is, if without agreeing with the parties involved in the contract of carriage, if ship says, well, I have to take bunkers, otherwise I'm going to carry a cargo. That is not a justification for a lawful deviation. It will still be treated as an unlawful deviation, and in order to treat it as a lawful deviation, the P&I club bunkering clause is always added that the ship will be deviating from its passage to a port where the cheapest bunkers are available, and if there is an additional cost on the part of the other parties, it will be mutually agreed upon and taken care of by the carrier, that is the ship owner, and it's a third party additional cost, P&I club, and the involved parties, they will mutually share the cost if at all there is a claim. So any that unlawful deviation has such serious consequences that if the ship, because of deviation, reaches late at the discharge port, the buyer of goods may be suffering a loss in the market. After all, he's not going to keep the goods in his home or in a warehouse. He has to immediately get rid of it. So the point is that when we depart, there are so many parties, we have to give the ETA to the port. Not only the port, but there are so many entities involved. We send it to the agent in the discharge port because, just a sec, because of the receivers of the cargo. So they have an approximate time of arrival, estimated time of arrival, and it's a known thing that Okay, it cannot be 100% down to the minutes, the ETA. It can be altered, but not if the change in ETA is phenomenal, then the investigation starts from the parties involved that why the ship was delayed, was there a deviation caused, that we need to take the carrier to court. So maintaining the ETA, you would realize that the masters are saying that if they are not, if we are getting less speed or something, that he jumps and he says that, okay, I want more revs, etc. The importance of ETA, because it should not lead to a conclusion that a deviation, unlawful deviation has been caused. Are we good with that? Equally important is that simple failure to commence loaded voyage and proceed as quickly is not a deviation in a legal sense. Now, next week, the first thing on Monday, we will be doing the note of protest and letter of protest. Why it is important that if the agent has told you that, okay, you completed cargo work at 1700 hours, you prepared the ship, the pilot boarding will be at 2000 hours, by 2200 hours, the pilot has not come. We don't just sit around. Master immediately says, call up the port that why the pilot is not coming. Because a delay in pilot boarding, by just saying it that we departed late from the port of loading because the pilot was late, is not sufficient. It has to be supported by LOP, letter of protest. Then it will not be construed, it will not be concluded as an unlawful deviation and no added cost to the carrier. Are we clear with this?
Yes, sir.
Okay, now that completes the thing about the bill of lading part of it. Now, a very common thing which is asked, explain the documentary credit system, the advantages, etc. The way we are going to discuss it, make sure you are writing or drawing the block diagram, step 1 to step 10, and that is exactly in the simplest way it has been conveyed to you in your reading material. The February reading material, you are getting it today, and I will be sending it. I was a little unwell yesterday. I could do it yesterday as promised. Now, can you see the blank slide? Just focus, understand the first thing. Documentary credit system. Can you see the blank slide?
Yes, sir.
Okay. Now, in the documentary credit system, there are 4 entities involved. One, the buyer at the discharge port. Then there is the seller at the load port. They may not have seen each other and they may not see each other for life. What is the interest of the buyer? That what contract I have signed to buy the goods from the seller, I must get the goods in my possession at the discharge port with no damage. What is the interest of the seller? That once the buyer has received the goods, I should get my full money. That is the reason that they both, the seller at the load port and the buyer at the discharge port, and this could be 2 different countries under different laws. So what these 2 people they do is they involve a bank. There's another reason for involving a bank, because banks are legal authorized entities. When they are involved in the whole transaction, they charge the fees. Both the buyer and the seller are sure of what they are there into the business for. So the third entity is that in the discharge port country, the buyer chooses a bank of his choice. The seller chooses a bank in his country. On behalf of the buyer and seller respectively, the bank authenticate the selling of goods, transfer of money, etc. Here also it will become clear, which I'll be indicating that why two original sets of bill of lading are couriered to the buyer. So let's take step one. Focus. Now, these are the four entities which are the 10 steps which will be undergoing, and we are doing the documentary credit system. First, step one, the sale contract takes place between the buyer and seller. They both sign. I am selling you this consignment of goods with these details. Buyer says, I'm going to buy this, and this will be the cost. Number two, now, buyer at the discharge port, when he has received the goods, what will be his first thing? To give the money to the seller for the cost of the goods that he has purchased. He may not have it. It can run into millions of dollars depending upon the cost of goods. So the buyer goes to the bank of his choice to apply for a loan. For example, that the moment the goods are going to be received, the ship is going to come in 10 days time or 20 days time. I must have the money ready so that once the goods have been received, the seller gets the money. So, like we apply for a business loan or a personal loan, etc., to a bank, that is separate from this whole contract with documentary credit system. The point is, the buyer and his bank, they sign that loan document that you will be getting this money. But no bank gives a business loan without a collateral. So, what is the collateral that is kept? Set of original bill of lading. That till the time you have paid the money to me, the buyer paid to the buyer's bank, I am the owner. The bank is the owner of goods. You don't pay me, I will sell the goods in the market and get my money. For example, when we take a loan to buy a flat, the flat papers are with the bank till the time we have not paid the EMIs and completed the thing. They are in possession. If we default, matter goes to court. Court says the property belongs to the bank. They have the paper, they can sell it. I'm just ended up sucking my thumb. What is the collateral kept by the buyer to the buyer bank? The original set of bill of lading. And yahan pe the importance come to order and the name of the bank. That is where the type of bill of lading comes. And here again important thing comes. If the bill of lading is dirty, if it is claused, that 5 packets were damaged, no bank will keep that as a collateral, and the buyer will never get a single paisa loan to pay the seller. That is why the buyer tells the seller tells the agent or the ship master at the load port getting down on his feet, Captain, please, please, please do not put a clause. Well, you be firm. Your job is to protect the carrier. Letter of indemnity is not sufficient because the buyer of goods can still take the carrier to court. What about your responsibility to ensure that the cargo was loaded in an undamaged condition, which we have already done day before yesterday? Only when it is a clean bill of lading, the buyer's bank will keep one original set of bill of lading as collateral. The second set of original bill of lading, the buyer must have in position because wahi to dikhayega. Based on that, along with him, the bank's representative will go to the carrier's agent at the discharge port. Yes, he has given us a set of bill of lading. He has taken a loan. We are keeping it as collateral. So you can give the delivery note for him to receive the cargo. Because if the buyer comes with that bill of lading, the carrier's agent says, okay, you are showing me the identity, but the person, the receiver of cargo, is the bank. So the bank will say to the agent that, okay, everything is fine. You can hand over the delivery note to this buyer. We have confirmed the identity with him. He is going to receive the cargo on our behalf. Are you with me till here?
Yes, sir.
Yes.
Step, and that's why I've written this. This is what 1 to 10. This is what stepwise it is there. You write it, and the interesting part of this whole thing is understanding and drawing this, because by just writing 1 to 10, you can just write it. Your answer is complete. Step 3. The buyer bank issues a letter of credit to the seller's bank. Now, all these full style details are already exchanged. Now, I'll digress a little bit to make you understand. The documentary credit system rests on this LOC, letter of credit. Now, what is this? Did you hear about that case, that diamond tycoon or merchant, that Nirav Modi, who's absconding and hiding in England or somewhere, I don't know where? You have heard about that case?
Yes, sir.
So
Yes, sir.
that guy got caught here in this letter of credit. What is the meaning of letter of credit? Now, what happens is, if suppose I want to, like he wanted to open one uh, diamond retail Swikey outlet in Manhattan in New York. He is an Indian citizen with an Indian passport. He goes there, he goes to a bank, he goes, let's say, on a tourist visa, multiple entry visa. I'm opening this, I want to take a loan. The bank will show him the door. Who the hell are you? You're not even an American citizen. So what Nirav Modi does is, he goes to his bank in Bombay and says, I want $10 million in New York to open this. So the bank will say, you give us a collateral, you keep your property as collateral, and we give you $10 million. So he's supposed to give that collateral to the bank, and Nirav Modi will tell his bank that I am going to be taking loan from, let's say, Bank of America or Chase Manhattan Bank. Banks in India also have that tie-up with various banks in various countries around the world. What Nirav Modi's bank will do is issue a letter of credit to that bank in New York. We have received the money from him. We have received the collateral. Please give him $10 million. It is our responsibility to give you the $10 million. And they have that arrangement. So when Nirav Modi goes to New York, he gets the $10 million based on the letter of credit, and the money is given. The bank in America informs the bank in Bombay of Nirav Modi, we have paid the money. Nirav Modi bank will transfer the $10 million to that bank, transaction complete. They are getting the EMIs from Nirav Modi, the bank in Bombay. Why he got caught was that he used to bribe, he chose one very small outlet of Punjab National Bank in Bandra. And he sent his executive, and at the assistant manager level in that small branch, along with 4-5 clerical people, they used to give them crores and crores of bribe that don't ask for collateral. We will pay you the money. This is your bribe. And the letter of credit was issued. This went on for years, maybe 5-7 years. A bribe was reaching there, the assistant manager. Now that guy got transferred. A new assistant manager, an honest guy, came. So when Nirav Modi sent his executives to the branch, कि भाई, I want another letter of credit to open somewhere in Malaysia or wherever. That guy said, okay, fine, but what about the collateral? So his executives started looking at each other and sarcastically laughing. अरे भाई, इतने सालों से तो अरेंजमेंट चल रहा है, कोई कोलैटरल नहीं है, आप लेटर ऑफ क्रेडिट दे दीजिए, ब्रीफ केस आपके यहाँ पहुंच जाएगा. That guy, assistant manager, was honest. He said, to hell with it. If this has been going, I need to find out. And that opened up the Pandora's box. So many thousand crores business was already going on without a collateral. the bank was issuing the letter of credit. So that is where he got caught. So coming back to it, buyer's bank will issue a letter of credit to the seller's bank. Why? Because after all, पैसा तो seller के पास पहुंचना है. Correct? And that is also the seller's interest कि भाई मैंने अपने एक बैंक को involve कर लिया तो my पैसा is guaranteed. They issue a letter of credit based on the freight or the cost of that good which has to be given to seller. Then the seller informs, the seller's bank informed that your money is standing by. The ship has sailed from the load port. It is in transit to the discharge port. Okay, sorry, not at this stage. So informs the seller, your money is standby. You can start loading the ship. Because the seller is also interested that I'll load the ship, ship will depart. But if my money is not guaranteed at standby, I may be ending up in the docks. So step 5 is, step 5 is seller loads the cargo on the ship. Shipped bill of lading is issued, which is to sent to the buyer, which he gives here as collateral. It is confirmed that the goods are on the way. After doing this, loading the ship, the shipper, that is the seller of the goods, he confirms back to the bank and submitting that bill of lading. एक तो उसके पास होती है, confirming that the master and or the agent of the carrier, they have signed in apparent good order and condition a clean bill of lading confirming the goods on the ship have been loaded and the ship has departed to the load port. This information is given by the seller to his bank in the country. The seller's bank informs the buyer's bank in the discharge port country, sends the copy of the bill of lading or whatever the arrangement, even the original. Although they already have the original as collateral, so it could be a copy, that the goods have been loaded. The goods have been loaded, ship has departed, and you should be ready to receive the goods. The buyer's bank informs the buyer that you can take your bill of lading and take the delivery of goods. You take the bill of lading, we will come with you because the bill of lading is in our name and you will have to submit your identity. We'll confirm that this is the same identity that he has submitted with us. You, the agent, please hand over the delivery note to the buyer at the discharge port for taking the delivery of the cargo. Once that happens, number 9. Oh, there is a lot of disturbance. The step 9 is that is step 9. Buyer's bank tells the seller's bank, release the payment on confirmation of receipt of goods. The buyer, after the ship has been offloaded completely, he will inform the buyer's bank. He'll inform the buyer's bank that I have received the goods in order and the money can be delivered to the seller. So based on the letter of credit, this was step 3. The buyer's bank will transfer, let's say, $10 million to the seller's bank. They will take their additional commission, reduce payment on receipt of goods, that they will tell the goods are received. You can give the money to your client. Once that is there, step 10, seller's bank releases pay to the seller of goods. This is the documentary credit system. Whenever the bill of lading is addressed to order and name of the bank, you can be 100% sure that documentary credit system is being involved. Have you understood this whole thing? Shall I do it once again?
Little recap, sir, for the
Okay.
whole.
Excellent. So I will keep it like this. so that the whole thing is there. And what you'll see on your note that half a page, step 1 to step 10 is written as it is. So there are 4 entities: the seller, that is the shipper of goods at the load port, buyer of goods at the discharge port, and they all can be in different countries. Buyer wanting to ensure that things are in order, plus I need loan money to pay the seller on receipt of goods. He will choose a bank. Seller wants to be sure that a buyer receives the goods and runs away. How do I contact him? When you are involving the bank, who have got an arrangement between themselves on the receipt of goods at the discharge port, my money is guaranteed. So that's the reason he chooses a seller of the bank. The one is the sale contract. This is the amount of cargo. That's why there are 2 arrows. This is the amount of goods, the consignment. This is the payment that you are going to give it to me. Buyer wanting to have money in a form of a loan, he goes to a bank to apply for a loan. What is the collateral? He keeps the clean bill of lading, which is addressed to the bank. On receiving that, this is order. This is step number 3 is the most important thing. The name is documentary credit system. So letter of credit is the most important. It is just a piece of paper. Buyer's bank will send a letter of credit. Okay. When we tell you, you please release the money, $10 million to your client, who's the seller. And this is the contractual arrangement in the form of letter of credit. Seller bank inform the seller, okay, whenever the ships come, you can ship the cargo, you can have the cargo loaded because your money is standing by. You will only get it when we get the instruction from the buyer's bank. That is confirmed by way of the letter of credit. Okay, very happy. The ship comes, the seller, the shipper, he loads the cargo with the shipper of goods. And when buyer is applying for the credit application, that time he will not have the bill of lading. So the letter of credit at this time, they don't send the money to the bank as an advance or something. No, it is waiting that we will confirm your credit loan application once you submit us a clean bill of lading addressed to us, so that we have got control over the cargo till the time you don't pay us the money. So on loading the cargo, 2 sets of clean bill of lading to order the bank. They are couriered to the buyer. That's the time his credit application gets completed. When he submits 1 set of bill of lading, for them, they keep it in their lock. Okay. Then number 6, after loading the ship, sending 2 sets here, he confirms with the sellers, with his bank, and because 1 original has to be there, so they are happy with the copy that, okay, I have loaded the ship. This is the proof. It is a clean bill of lading on face of it in order, good order and condition. Please inform the bank of the seller there in the other country. So number 7, with a copy of that, they said that, okay, confirm shipment, and they confirm that copy sent by courier or electronically scanned, that the original bill of lading which he had submitted to complete the credit application as a confirmation that the goods have been loaded, the copy and the original we confirm up till now the things are in order. Buyer's bank tells the buyer, you can take the delivery of cargo, the cargo has been loaded, and please inform us when you have received the cargo to your satisfaction, because we will have to release the payment to the other guy's bank in that country. So release doc the buyer to take delivery. The buyer confirms. He cannot run away, because the importance of the letter of credit is this bank and this bank have legally got joined. Only when they have got joined, the seller's payment is guaranteed. If he comes to know from the carrier's agent, the way we have delivered the goods and he has not received the payment, he doesn't have to go and chase him. He will just go to the bank. After all, he's paying the commission to the bank. The bank will run after this bank that you have issued the letter of credit, and that's how I got the client. Where is the money? So that is also the reason advantage of involving the bank. So when the buyer confirms that I have received the goods based on this letter of credit, buyer's bank will tell the seller's bank that release the $10 million what the letter of credit was for. I had said to you in step 3, seller's bank cuts the commission, release the payment of $10 million, which is there in the sale contract to the seller. Got it?
Yes, sir.
So this is your documentary credit system. We have got 10 minutes. And today, sometime in the afternoon, before lunch, I'll be able to send it to the February batch, and it is all there. You practice, I mean, there are 4 blocks. Only thing that you have to, logically, there are 10 steps, 4 blocks. What will be the movement? Every arrow is one-sided except this. This is two-sided, the sale contract. My thing is, you take my audio and video, just go through it. Once this diagram is in your mind, the documentary credit system is in your pocket, you don't have to memorize anything, you just have to do that.
So one question, sir.
Please go ahead.
So this the seller which is giving to the seller's bank this BL, he is giving 2 original copies, correct? The 2 originals.
No. Seller, see, there are 3 sets of original which is there. Yes, 2 sets of original are sent to the buyer by the courier. Why? Because one original set he will submit here, one original set he has to keep it with himself to take the delivery of cargo. One set remains with the seller. The carrier only has a copy of it. I mean, we have a confirmation that we have shared it. So 3 sets, 2 sets here, 1 set here.
But the 2 sets that the seller has, he has to give it to his bank.
No. When the cargo is loaded, 3 original sets of bill of lading are signed. 3 original sets. Okay. And they are handed over to the seller. Out of those 3 original, 2 original, he sends it to the buyer. 1 original is here. Now, it is an arrangement with the seller's bank that to confirm that the ship has been loaded, that you submit the original bill of lading. That is very rare, but it is a possibility. Original remains with him. He gives a copy to the seller's bank confirming that I have loaded the ship and I have the shipped bill of lading, which is to order the bank. And they keep 1 copy with themselves, take another copy and send it to the buyer's bank, confirming that the ship has been loaded in good order and condition. So coming to the 3 originals, 2 are here, 1 is here.
The 1 original with the buyer, he has to give it to the buyer's bank to get the loan.
Loan. And only then the buyer's bank will have that. That is the collateral here. If instead of the cost of the goods, they say, I will keep my hotel. I am owner of an hotel. I'll keep that as a collateral. ठीक है यार. I am happy that then both the original BLs will remain with the buyer. What he wants to do with the second original, it's up to him. But the point is, 1 set of original BL, he will have to go along with the buyer's bank representative to the carrier's agent in the discharge port. Yes, the bill of lading is, I've got it addressed to the bank. I had that arrangement with the seller because I'm taking a loan from him. The bank's representative will tell the agent, yes, he's the guy who has taken the loan and he's the actual who's supposed to take the delivery. So please hand over the delivery note to the buyer. He will take the delivery of cargo on our behalf. We will remain the owner of the good because that is the collateral.
Okay, sir. Understood, sir.
After submitting 1 BL of BL to the buyer bank, the buyer goes through the bank, gives this all document to the agents. Then the agent give to the buyer
note.
at the delivery note goes correct to the agent that is appointed by the buyer. at the discharge port.
No,
Then-
that is the carrier's agent, ship's agent.
Carrier.
हाँ.
Okay. Thank you.
Because agent का मेन काम बिलीव भी वो कैश टू मास्टर शिप शैडलर वो सब तो फालतू फंड का वर्क है. मेन वर्क ये होता है एजेंट का फॉर रिलीज ऑफ द कार्गो फॉर इफ रिक्वायर्ड. अगर टाइम लगेगा there are too many small packages तो I need a mate's receipt to make the BL later on etc. वो सब मेन काम होता है उसका एजेंट का.
And sir, if buyer is not taking loan, then how this sequence will go?
Okay, then the documentary credit system is not applicable. He says, okay, sale contract, the seller will say, before I load 90% of the cost of the cargo, you deposit in my bank, only then I will load the ship. So he deposits 90% in his bag, he loads the ship, sends him two sets हमेशा buyer के पास होती है. Always. One set he will keep it with himself till the time the whole transaction, the sale is complete. One set he will go with the ship's agent in the discharge port. But this is, I need the delivery of cargo. Delivery of cargo taken, I am happy. Remainder 10% given to the seller's bank. There is no question of involving the bank. That in that case, tell me something I did the day before yesterday. Instead of a BL, he'll have a CWay bill. Yeah, my payment is guaranteed. Yeah, so क्या document of title? ठीक है, पैसा भेज देना है. Got it? That's how you join the dots. So practice this diagram. I'll just mute my audio and video for 5-7 minutes till 10 o'clock. We are there. Tomorrow onwards, I'm going to start on the charter parties. I've got 2 lectures tomorrow and 1 lecture day after tomorrow. I think I should be able to finish the entire commercial law this week. Maximum 1 more lecture on Monday. Then I'll spend 2 lectures on MSA. But before that, I will go to the very important thing, letter of protest, note of protest. So you have followed this whole documentary credit system. It is very easy to understand once you understand the logic. Correct?
Yes.
Great. I'll just see it 5 minutes and then we'll knock off for the break.
सर ये जो लॉ का हैंडआउट है
हाँ. Go ahead.
सर ये जो अपना लॉ का हैंडआउट है वो फुल सिलेबस है पूरा उसके
Absolutely. 1 second. You are from the February batch?
यस सर.
Okay, you wait. That is the full syllabus. You keep it aside. But what I'll be sending you as my own notes, that will be more than sufficient. You don't worry on that.
ओके